Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update on the Constitution Bench of the Supreme Court, which today reserved judgment on the issue whether private resources form part of the material resource of the community under Article 39B of the Constitution. The court concluded the hearing after 5 days of arguments raised on the issues of what constitutes a community, the subjective undertones of material resource, as well as the fate of Article 31C post the decision in Minerva Mills versus Union of India. The 9-judge bench considering the issue comprises CJI D.Y. Chandrachud, Justices Rishikesh Roy, B.V. Nagratna, Sudhanshu Dholia, J.B. Pardiwala, Manoj Mishra, Rajesh Bindal, Satish Chandra Sharma and Augustine George Massey. Article 39B is one of the directive principles of the state policy, and it states that the government should create policies to share community resources fairly for the common good. It implies that both state-owned and privately owned material resources should be managed in a way that benefits society as a whole rather than serving the interests of a privileged few. The main question to be decided is whether material resources of the community under this article includes privately owned resources or not. The contention of the appellants was that material resources should mean any resource that can create wealth like goods or services for the benefit of society. And if the law meant to include privately owned resources in the definition, then the drafters would have said so clearly to prevent any confusion later on. The Union of India argued that Article 39B should be interpreted by looking at the growing principles of the Constitution and not through any specific belief system. It said that a resource should be considered as to how people in a community interact with each other. Every person has their own dealings and businesses, and all these together make up the wealth of the community. So, according to the Union, a resource under Article 39B means the shared economic foundation of a community built by everyone's economic activities. You can visit livelaw.in to read the arguments made in detail. A plea has been filed in the Supreme Court by a lawyer seeking constitution of a medical expert panel to examine side effects and risk factors of the Covishield vaccine, as well as compensation of those who were severely disabled or died due to the vaccination drive. This comes after reports of British-Swedish multinational pharmaceutical and biotechnology company AstraZeneca admitted that its Covishield vaccine can cause rare side effects. The company has admitted that its AZD1222 vaccine against COVID-19 sold as Covishield in India can cause low platelet count and formation of blood clots in very rare cases. Covishield was developed by AstraZeneca and was produced by the Serum Institute of India. The present plea adds that more than 175 crore Covishield vaccines were administered in the country, and that since COVID-19 pandemic, there has been an increase in the number of deaths due to heart attack and sudden collapse of persons. The plea states that vaccines were administered on Indian government's assurance that it was safe. Thus, it has prayed that those severely disabled by the vaccine should be compensated and the union government should take up the matter on priority. The Supreme Court in an important ruling has observed that Hindu marriage is a sacred institution and should not be trivialized as a mere social event for song and dance and wining and dining. The bench of Justices B.V. Nagratna and Augustine George Massey said so while deciding a petition filed by a wife seeking transfer of divorce proceedings against her husband. During the pendency of the case, the husband and wife agreed to file a joint application for a declaration that their marriage was not valid. They stated that there was no marriage solemnized by them as no customs, rites and rituals were performed. However, due to certain pressures, they had to obtain a certificate of registration, and a certificate of marriage was issued by the Registrar of Marriages. The court noted that no marriage was solemnized and declared that there was no valid marriage in this case. But apart from this, The court also made certain other important observations. It said that marriage ceremonies must be followed with perseverance and that there could be no registration of a Hindu marriage if it has not been performed as per the customs. The bench urged young individuals to deeply consider the sanctity of the marriage before committing to it. That marriage should not be approached as an occasion for extravagance or as a means to demand dowry or gifts, but as a solemn occasion that establishes a lifelong union between a man and a woman, forming the foundation of a family, which is a fundamental unit of the Indian society. Have you heard about Chinese manjha or Chinese kite string or Chinese thread? It is a type of a kite string that is coated with a mixture of finely powdered glass or metal. This coating gives the string a sharp cutting edge, making it extremely dangerous. It is often used in kite flying competitions where participants attempt to cut down the strings of their opponent's kites. The sharpness of the string can cause severe injuries to humans and animals. There have been numerous cases of people getting cut by the string while flying kites or even by just being in the vicinity of kite flying areas. In this regard, the Delhi High Court is dealing with a bunch of pleas highlighting the menace of manufacturing and sale of Chinese manjha for kite flying in Delhi. Earlier, the court had directed the Delhi police to continue taking steps to restrain the sale of Chinese manjha in Delhi during the Independence Day season. Justice Subramaniam Prasad has now directed the Delhi government to frame a policy for grant of compensation to those who have lost their lives and limbs due to accidents from the sale of Chinese manjha in the national capital. The state government has directed to frame the policy and file it in court within 8 weeks. The matter will now be heard in August. Stay tuned. In another update, the Supreme Court's registrar has refused to receive the application filed by the union government seeking clarification of the 2012 judgment in the 2G spectrum case. In the 2G case verdict, the Supreme Court had set aside the first-come, first-served basis for assignment of 2G spectrum. The court also observed that public auction should be the preferred method for the allocation of public resources like spectrum. The government now sought a clarification that the verdict does not bar allocation of spectrum through means other than public auction in certain situations. Stating that the application was actually seeking a review of the judgment in guise of seeking clarification, the registrar rejected it by terming it misconceived. Let me tell you, as per Order 15, Rule 5 of the Supreme Court Rules of 2013, the registrar can refuse to receive a petition if it discloses no reasonable cause or is frivolous or contains scandalous matter. The registrar here also cited the time gap of nearly 12 years in filing the application. Also, let me tell you, as per the Supreme Court Rules of 2013, the centre has the remedy of appealing to the court against the registrar's order. A Delhi court has pulled up the Enforcement Directorate for invoking Section 50 of the Prevention of Money Laundering Act to record the statements of private doctors in a money laundering case. The doctors here were consulted by an accused, Amit Katyal, after being admitted to interim bail in the case. This was done to oppose Katyal's plea seeking interim bail extension. Special Judge Vishal Gogne of Rouse Avenue Courts said that as an investigative agency, ED is bound by the rule of law and cannot be seen as acting mighty against the ordinary citizen who is not even a suspect. This Section 50 basically allows authorities to call in individuals for questioning and gathering information related to potential money laundering activities under the law. What makes this section peculiar is that it grants the power of arrest without an arrest warrant. The court added that there was absolutely no justification for the Enforcement Directorate to subject an ordinary citizen to the stringent process of Section 50 without an iota of allegation of nexus of the doctors with the allegations of money laundering against Katyal. However, the court declined Katyal's plea to extend interim bail as he was in a recovered state of health and was permitted normal physical activity. The Supreme Court has commented about the practice of advocates filing minutes of order. This is a peculiar practice followed at the Bombay High Court, where advocates on both sides mention the points which are to be included in the judgment to be passed by the court. While this practice is to assist the judges, the top court has cautioned that care should be taken to ensure that the rights of the third parties are not affected by passing orders based on the minutes of order. Further, the High Court must apply its mind to such minutes of order to ensure that the order proposed to be passed is lawful. A bench comprising Justices Abhay S. Oak and Ujjal Bhuya made some important observations while dealing with a case where the Bombay High Court permitted construction of a compound wall under police protection, relying on minutes of order presented by the advocates in the case. The appellants opposed this decision, claiming that it overlooked objections from government officers and failed to involve affected parties. Despite these objections, the division bench upheld the order without providing reasons. The Supreme Court found the High Court's order as illegal and remanded the matter back. To read this in detail, please visit livelaw.in. Lately, people have been talking a lot about judges' vacations. Some have been questioning as to why judges take breaks when there are so many cases pending in courts. They have also been comparing the number of days judges work with the large number of unresolved cases. Judges have responded to this public criticism quite often. An interesting discussion regarding the vacation of judges took place in the Supreme Court. This was when the bench comprising Justices B.R. Gawai and Sandeep Mehta was hearing the suit filed by the state of West Bengal against the union government over registration of FIRs by the Central Bureau of Investigation. While posting the matter tomorrow, Justice Gawai suggested that the arguments be completed before the court closes for summer recess on 19th May this year so that the judgment can be written during the vacation. Solicitor General Tushar Mehta humorously suggested not wasting the vacation on any matter, given that judges have heavy workload and that they deserve a vacation. To this, Justice Gawai replied that vacations are mostly used to write judgments in complex matters. He further stated that people who criticize judges for vacations do not realize that they do not get holidays even on Saturdays and Sundays due to conferences and other assignments. Senior advocate Kapil Sibal, who was also present in the court, said that it is the toughest job in the country. In an important update, the Madras High Court has issued a slew of guidelines to eradicate manual scavenging and to ensure compliance with the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act of 2013. The bench of Chief Justice S.V. Gangapurwala and Justice Satya Narayan Prasad was hearing a plea by Safai Karamchari Andolan seeking to eradicate manual scavenging in the state and implement the Prohibition Act. It remarked that though there might have been a need for manual scavenging in an age of absence of technology, but continuing the practice in today's age with technological advancements was nothing but state-sanctioned casteism. The court asked the state to strictly implement and comply with the 2013 Act. It also asked to enhance compensation for deaths and permanent disability due to manual scavenging work and to frame a scheme for offering compassionate appointments to the family members of deceased scavenger workers. The court underlined that all efforts must be taken to eradicate manual scavenging in a phased manner by the year 2026. And lastly, a Delhi court has sentenced a 50-year-old man to life imprisonment for raping his 11-year-old minor daughter soon after her mother's death, observing that the offence does not deserve any leniency. Additional Sessions Judge Anu Agarwal of Saket Courts said that where a child is sexually abused by a family member, especially biological father, it is nothing less than betrayal of trust and impairment of social values. The convict had 3 children, including the victim, who is 16 years old now. The victim impact report stated that she was 11 years old when she was raped by the father. The victim suffered mental trauma due to the incident and is presently living in a shelter home. Such an offence, the court said, leaves a long-lasting emotional and psychological impact on the child. It leaves permanent scars on the psychological health of the child, and these scars are invisible and cannot be measured by any yardstick. The court said that these invisible scars haunt the child throughout life, and the child loses the trust in family and friends and in the society. The court also ordered a final compensation of Rs 12 lakhs to the victim under the Delhi Victim Compensation Scheme 2018. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.